A recent case where a professor was dismissed after an Internal Complaints Committee (ICC) found him guilty of sexual harassment under the POSH Act 2013 marks a rare yet important precedent. While this outcome is celebrated as justice served, it also exposes the persistent gaps that prevent the Act from delivering consistent empathetic justice, especially in academic cases where power imbalances are steep. The law was a landmark when enacted in 2013, but a decade later, its structural weaknesses have diluted its ability to protect women effectively. One of the central flaws lies in the Act's conception of consent. It recognizes consent but not informed consent. In workplaces and universities, relationships may appear consensual initially, but when manipulation, coercion, or misuse or authority emerges later, the earlier consent becomes invalid. Yet, the POSH Act does not consider emotional manipulation as harassment, leaving a large gray zone where educated perpetrators exploit trust and information gaps without leaving explicit evidence. Emotional harassment, deceit, and psychological coercion remain outside the legal radar. Another major flaw is the 3-month limitation period for filing complaints. Survivors of manipulation or trauma often take far longer to recognize abuse and gather the courage to report it, especially in universities where students live several years under the same institutional ecosystem. The rigid timeline emboldens perpetrators who rely on the passage of time to escape accountability. Language also weakens the seriousness of the offense. Calling the accused a respondent softens the gravity of acts that would otherwise be crimes outside the workplace context. The burden of proof remains disproportionately on the survivor. Harassment is often a behavioral pattern, not a single act, yet committees frequently dismiss complaints for lack of direct evidence. The Act needs mechanisms such as anonymous testimonies and behavioral assessments to recognize patterns of misconduct. The law is also silent on interinstitutional complaints, a serious gap in academia where faculty and students often interact across campuses, allowing repeat offenders to go unchecked. The rise of digital communication has further complicated evidence collection. Vanishing messages, encrypted chats, and disappearing media make it difficult for ICC members who often lack technical expertise to assess digital evidence. The Act must update its definitions, protocols, and training requirements to match these technological realities. Finally, provisions penalizing malicious complaints intimidate genuine survivors and risk re-traumatizing them. While the POSH Act was a historic step forward, it now requires stronger language, longer timelines, recognition of emotional and digital abuse, and improved investigative tools. Justice must be embedded into the structure of the law, not dependent on a victim's endurance or committee discretion, to make the Act truly effective in 2025 and beyond.